Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein, Becker, Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Hello, everyone, and welcome to Diagnosing Healthcare. I'm your host, Tim Murphy, an attorney in Epstein, Becker, and Green's healthcare and life science practice, based in our Boston and Washington, D.C. offices. In today's episode, we are going to discuss the 2020-2021 Supreme Court term and the current cases with the greatest potential to affect the healthcare industry: California versus Texas and Rutledge versus PCMA. California versus Texas is the latest in a line of cases dating back to NFIB versus Sebelius to challenge the constitutionality of the Affordable Care Act. While the issue before the court in Rutledge versus PCMA is whether ERISA preempts an Arkansas statute regulating pharmacy benefit managers' drug reimbursement rates. We will also touch upon the changing makeup of the court and what it might tell us about the future direction of its jurisprudence with respect to laws which have the most impact on the healthcare industry. Joining me for today's discussion is Stuart M. Gerson. Stuart is a member of the firm in the litigation and healthcare life sciences practices in the Washington, D.C. and New York offices. Stuart was appointed Acting Attorney General of the United States during the early Clinton administration after having served as President George H.W. Bush's appointee as Assistant Attorney General for the Civil Division of the Department of Justice. He has also served as an advisor to several presidents. Welcome, Stuart.
Glad to be able to address the issue of the Supreme Court, because there's lots of speculation about what this term is going to hold facing a new administration.
A new administration and a new court in some ways too. So to kick off our discussion, I was hoping to hear your thoughts on the changing dynamics of the court. Obviously, we have relatively new members and then a brand new member.
Well, there is going to be a change on the court. I should say changes, not just change. Of course, on the surface, the most important thing that has happened is the sad passing of Justice Ruth Bader Ginsburg, a very influential justice on the liberal side, but not the knee-jerk that many people thought. Her passing, is going to have effects in a number of ways, because while Justice Ginsburg was very liberal when it came to employee rights and benefits, she always would have preferred a constitution that was a benefits rather than a rights constitution. She also was on the conservative side in many business and tax cases. So at least on the business side of healthcare, she will be missed, at least in some category of cases. Amy Coney Barrett comes onto the court to replace Justice Ginsburg, and Justice Barrett is considered to be someone in the mold of her mentor, Justice Antonin Scalia, for whom she clerked. But time will tell. I mean, we get surprised, and rather quickly so, by appointees. And looking at how, for example, Justice Gorsuch has reacted in several recent cases, you know that there are no sure things. But it will be very interesting how Justice Barrett rules in conjunction with Justice Alito and Justice Thomas, and perhaps others, in cases where reproductive rights and other healthcare issues come up against arguments about freedom of religion, conflict between the First Amendment and the more abstract right that was defined in Roe against Wade. But by your leave, let's talk about the two pending cases, one just argued, that really are going to affect healthcare, and I think in more predictable ways than we might have thought had we done this some days ago.
I think that you're referring to California versus Texas with that, which is where I'd like to start. I think it is the case with the greatest potential impact on the healthcare industry this term. And I was hoping maybe we could do a high-level overview of what the issues at the core of California versus Texas are.
Well, I'll talk about that, and I'll talk about how the oral argument that was conducted a few days before this recording might have tipped the hand of the way that the court is likely, in my opinion, and many others, to go. So that all of our listeners are fully apprised, California against Texas is a case that has become a major political issue, and that will, along with Roe against Wade, be the subject of much of the examination of and speculation about Justice Amy Coney Barrett. I respectfully suggest that while politicians and interest groups can raise both substantial fears and a lot of money over the issue concerning whether the Affordable Care Act will survive, and in the absence of the provision that the Chief Justice interpreted to uphold the ACA in the NFIB against Sebelius case that you talked about, I think it's very likely that a majority of the court is going to apply traditional notions about standing and severance and leaves what remains of the Affordable Care Act intact. I'll detail that in several ways, but both in the oral argument and in a concurrence in a completely unrelated case, Justice Kavanaugh, as well as more moderate or liberal justices, have generally given affirmance to the idea that judicial economy generally mandates severance of an offensive provision rather than the wholesale nullification of a statute. There's a fundamental merits fact that impels that conclusion, although I'll detail it more later. You'll recall that the Chief Justice joined the liberals in upholding the ACA based on his view that the mandate sum of money involved was a tax, not a penalty, and therefore upheld it. There's a fundamental merits fact, though, that relates to what happened. Congress, more lately, eliminated the mandate and zeroed out the tax or penalty. Take your choice, depending on what your orientation might be. The court has made it clear that it doesn't make any difference. It's gone. But having done that, Congress left all of the other provisions of the Affordable Care Act, and there are a lot of them, in place. Some of them are very important to healthcare. For example, guaranteed issue about pre-existing conditions not being a barrier or preventing the issuance of health insurance. But most of the other provisions have nothing to do with healthcare. Things like amendments to the False Claims Act. Well, that may affect healthcare indirectly. I'll come back to the False Claims Act later, but there's a boatload of things that have really nothing to do with the arguments about purchasing or not purchasing health insurance. As many on the court, if indeed most of the court, observed during their questioning, I mean, Congress, give them a little bit of credit. If they wanted to X out the entire Affordable Care Act rather than one provision, they really could have done that. That's the big overhang that's going to impel everything else. Tim, you have something you wanted to ask?
I just wanted to say Congress tried, and I think the Chief Justice brought it up in oral arguments, that Congress, in fact, tried and did not repeal the Affordable Care Act immediately before the tax package, which zeroed out the penalty.
Indeed, the Chief Justice remarked that, in his view, what the Congress was trying to do was pass the ball over to the courts, and the Chief Justice said, "That's not our business."
Right.
So you know that isn't going to happen. Okay, you want to know what the issues are in the case. The first and big issue is that of standing. There are two categories of plaintiffs in this case. Some individuals who claim that they purchased insurance under the impetus of the fact that they're commanded to do so, albeit without a penalty. And then there are states, particularly Texas, which argues that it is suffering some administrative costs as a result of the mandate having been struck, but the rest of the Affordable Care Act. And so with the command still there, more people are going to sign up for health insurance, and many of those people, indeed most of them, as has been the case in the past, are going to be Medicaid subscribers. Many of the justices, perhaps most of them, have real skepticism about both of those things. The individuals can purchase or not purchase health insurance without anything happening to them. And it's a real question as to whether the moral suasion of the command of the Affordable Care Act to do so, to buy insurance, is going to have any effect on them at all. And with respect to the states, while they make an argument that I think is a better argument for standing than the ones that the individuals are making, they still haven't very well documented these costs in any specific way. And several justices expressed skepticism, if you will, about their standing in the case. Well, standing work, they got by below. There's a real question of whether that will happen in the Supreme Court.
And for our listeners, Stuart, that might not be constitutional lawyers, or I think we have listeners from around the industry and around the legal world as well. The problem here is a particularized, cognizable harm that the plaintiff has to demonstrate in order to establish standing. Is that correct?
Yeah, I'd have thought that everybody listening to this, like I, has a copy of the Constitution sitting on their desk. But in the event that doesn't happen, Article 3 of the Constitution defines what the jurisdiction of the federal courts is. The courts don't issue advisory opinions. A plaintiff has to come in with standing. That is, he, she, it has to demonstrate a cognizable injury that can be remedied by an order in the case. You have to demonstrate harm in fact, not just a theoretical harm. And so that's the first barrier that any plaintiff has to get over, and that's the first issue that the Supreme Court has to deal with here. You come then to an interesting question, putting aside the question of standing, and where it is that the defenders of the Affordable Care Act at least have an intellectual problem. And my friend Don Verrilli, who argued for California, gave a good answer to this question. The individual mandate might have been essential to the Affordable Care Act's overall plan for healthcare reform, except now when it doesn't need to be. The justification for the Affordable Care Act was you had to have this mandate with a tax or penalty, again, take your pick, in order to compel people who are healthy to purchase health insurance they might otherwise not have wanted to purchase. And that would avoid adverse selection in many, if not most, of these plans. That was the idea. So what exactly is the rationale for the Affordable Care Act when you can't do that? Without that mandate, don't you eliminate an essential feature of the Affordable Care Act that ought to make the whole thing fall down? Well, a Texas judge believed that that was the case. But there's a good answer to that question, which is this case is now. The passage of the Affordable Care Act was then. Now follows the repeal of the mandate. And what Congress knew is that the mandate was never really enforced. The Affordable Care Act worked in the sense, while there are many things that one can argue are wrong with the Affordable Care Act, and as a conservative, I'd be happy to do that under other circumstances. But you can't complain about the fact that many millions of people signed up for health insurance under the Affordable Care Act, notwithstanding the fact that the mandate wasn't doing anything. And the plans are not screaming about adverse selection since then. Writing on a cleaner slate, the Congress, whatever it was that the Congress wanted to do, they, in Xing out the mandate, knew that they weren't going to create a national calamity where health plans were going to fail all over the place. On the other hand, we're now faced with a situation where you very well could have a national calamity if the court were to invalidate the entire Affordable Care Act, and 23 plus million people suddenly would be without health insurance and no place to buy it if states like Texas had their way. So that's a reality of the case. Where does this come down to? I mean, it suggests first and foremost that the court could hold that the remaining provisions of the Affordable Care Act are not unconstitutional, but I don't think the court's going to do that. I don't think the court needs to do that. I think that this case, Tim, is going to come down to the issue of severability. What does that mean? Well, it's a surgical concept that is well known in the law. Justice Kavanaugh wrote a terrific concurring opinion in a completely unrelated case last term describing these circumstances, and he made it very clear at the outset. The very first thing that he had to say in his questioning time says, isn't this a classical case of severability? What does that mean? It means you can excise an offensive provision without eliminating the rest of the legislation that's at issue. Why is that a principle that the court follows? Well, it's a principle of judicial economy. It means that much of what the legislature has done, or as much of what the legislature has done, can be left in effect. The court doesn't have to reach issues that it wouldn't otherwise reach. And so this is a good thing, and it acts in the minimum way necessary to afford substantial relief. Not only did Justice Kavanaugh raise this point, but the Chief Justice did too. And I think we can see the three liberal justices, Breyer, Sotomayor, and Kagan, are going to uphold the Affordable Care Act. So I count 5 right there without hearing from Justice Gorsuch or knowing what the other 2 are going to do. I think that that is likely to happen. Now, the court almost never in the past has reached the issue of a merits issue like severability without first ruling on standing. And standing here is questionable. So the court could bounce the case on standing. It could provisionally say that perhaps the state has greater standing than the individuals. And then it could reach the issue of severability. It could go to severability directly. The court understands that that would be something unique to do, but that's the way the case is going.
And just from diving in from a legal standpoint rather than a healthcare standpoint, then I will want to pivot back to healthcare. But the standing issues would be more novel and have a greater impact on future jurisprudence from the court, is my understanding, rather than if they were just to rule on severability. Is that your view as well?
Well, yes. And again, as from a conservative standpoint, and I represent a lot of companies in healthcare that have the same point of view, that believe that they're getting sued by people who lack standing, who are not injured. That's a very common problem in cybersecurity cases related to healthcare. People like that would be very happy if the court would tighten up on standing and injury. The court very well may do that. So I, for one, would welcome that. So would many of our clients. Of course, the plaintiff's bar and the public interest bar would like a more lenient view of standing than the court is likely to adopt. The premise of your question is a correct one.
Which, of course, brings us to many of the interesting things that happen at the court, where we have strange bedfellows often arguing different points of view than they might have otherwise. I think it's safe to say that many of the supporters of the ACA, which would not like to see it struck down, fall into the camps of folks that would normally like an expanded view of standing as well.
Well, that's true. Emerson says something about a foolish consistency being the hobgoblin of little minds. Where you stand depends on where you sit is another shibboleth of both life and the law. You do find strange bedfellows, but I think that wherever one rests, he, she, or it are going to be dealing with the Affordable Care Act. And what will be interesting about that is where the next administration is going to go.
But turning now to the potential impact, although if you have other thoughts you want to share, Stuart, on the legal portion of the arguments, I'm delighted to hear them.
I would tell our listeners the thing to look out for, besides different coverage issues that others have discussed and other regulatory issues, will be issues of transparency. There's bipartisan support for eliminating the issue of things like surprise hospital bills and having greater transparency with respect to pharmaceutical prices. These implicate ERISA issues and other matters, whether they're linked to the Affordable Care Act or not. You can expect a lot of action on those things, besides some of the things you might have heard about. So let's move on to Rutledge before I take the rest of this talking about legislation.
Well, what a wonderful transition into ERISA. So Rutledge is a less well-known case, I would say, than California versus Texas, but it nevertheless does have the potential to have an impact on significant portions of the healthcare industry. The issue before in Rutledge is whether or not Arkansas can regulate certain interactions between PBMs, or pharmacy benefit managers, and pharmacies. And several other states, if not the majority of jurisdictions, have similar laws. It comes down to an ERISA issue, which I'm going to kick back to Stuart to talk a little bit about, which is a fairly complex legal and regulatory scheme.
Rutledge was a case as to which I found it very surprising that cert was granted. I would have thought, or I did think, that PCMA's opposition to cert would have prevailed. But given the fact that cert was granted, case is yet to be argued, but one would expect that there were at least four justices who believed that there was a split in the circuits as to the extent of ERISA preemption, and that a clearer rule needs to be set down. So I don't think that this is going to be a momentous case. What it's going to be is a unifying case, that there really is, at least the court feels that there's a split in the circuit. The issue before the court, as you were suggesting, is whether the Eighth Circuit, that's where cert comes from, erred in upholding that an Arkansas statute regulating pharmacy benefit managers' drug reimbursement rates, which is similar to the laws enacted by a majority of all the states, whether that is preempted by ERISA and that contravenes Supreme Court precedent that ERISA does not preempt rate regulation. So that is what the case turns on. As I say, however this comes out, it looks to me like the sort of case that Justice Thomas specializes in. He tends to like those, what to most people are very dry cases. I would not be surprised if he ends up writing an opinion for most, if not all, of the justices, unifying the law of preemption, because it's going to come up again in other contexts. PCMA noted in its briefs, and why I thought that the court wouldn't take the case, is that the regulatory fact pattern is very confusing. But I don't think that the court necessarily took the case to reverse. I don't know how it's going to come out, and I don't make a prediction on that. But I do think the factual issue is that the petitioner claims diverges from other precedent is so narrow that PCMA is likely to prevail as to the holding favoring preemption. That's speculation on my part. What I think we'll get out of this case is something that will be useful in any event, and that will be a clearer rule on the boundaries of preemption. There's a federalism issue at the heart of all of this. And Tim, going back to your quip about strange bedfellows, a lot of the conservative justices are Federalists, but they also come from backgrounds like ours, which recognize that our clients, many people, certainly businesses that conduct their operations nationally, including healthcare businesses that are involved in multi-state activities, would prefer consistent national rules rather than a melange of often conflicting state rules that leave them in a quandary. And yet many of these conservative justices are torn between a natural inclination about federalism and a desire to have consistency in the law. This comes up in a lot of areas. And here's one where it naturally comes up. ERISA preemption has been somewhat elastic. We'll get a little less confusion. I said earlier that transparency is going to come up. Well, again, for national rules about transparency to take effect, ERISA has to be preempted. What the court says in Rutledge is very likely something that could affect litigation under the Biden administration with regard to transparency, even transparency issues that have a lot of bipartisan support in the Congress. Well, time will tell about that.
Put a finer point on that. That's under the assumption that it is not done through legislation that would obviously have the opportunity to amend ERISA so that it could have price transparency aspects.
Well, that's right. But what we know is Congress is always reticent to do that.
Right.
You get into debates about that, and it's hard to know where the Congress will come out. I mean, I have been arguing in cases that Congress ought to be a lot more active than it is, protecting its own prerogatives, particularly the power of the purse. But we'll see what Congress is like. Will it function as a parliamentary Congress, which it's been doing all too often, or will it strike an independent view and take clear positions without trying to bet on what the courts are going to do? And I think it's somewhat likely that that's going to happen. To go to your initial question, how are things likely to change? Well, with arguably a more conservative court, it is more likely that the Congress is not going to want to bounce things, where it has a majority, is not going to want to bounce things to the court for interpretation. We'll see. Are we going to have a 50-50 Senate with Vice President-to-be Harris casting the deciding vote? You have to come back in January to see how the two runoff races in Georgia are going to go to know about that. So there's, again, a lot pending and plenty of tale to be told.
And even if Congress was to act, there's no guarantee that they would do so in a manner that, correct is not quite the right term, but is without need for litigation afterwards under the ERISA statute, right? So they could amend it in a way that still leaves a chance for further court cases to come.
They always do. So let's see what happens this time.
Which brings me to another question that I had that is not on the two cases that are currently before the court, but obviously there are several cases pending cert. And I was wondering if there are any that you are particularly interested or monitoring for next term.
I'd like to cast some attention on a few issues under the False Claims Act. A lot of our clients are subject to fraud investigations based on very nebulous claims of fraud, oftentimes by dissident employees. And there's a lot of confusion. The False Claims Act is certainly an important tool for the government to fight fraud, but there are a great many cases that healthcare companies face that are not particularly meritorious, but are very expensive to defend, and often lead to settlements in cases that might have been defeated, and often lead to cases that make a lot of bad law. What is it that is being complained about? Well, with amendments to the False Claims Act, including amendments to the Affordable Care Act or provisions of the Affordable Care Act that make it easier for plaintiffs or relators to bring fraud cases in the name of the United States, the bar is pretty low. But the bar remains high enough, at least, that issues of materiality and standing are still important. In both regards, the court is being asked constantly by disappointed companies to rule that at least plaintiffs have to have some cognizable injury in fact, not a hypothetical worry about things that go on in healthcare. Let me give you an example. In virtually every case that involves a data security breach, a privacy breach, in which, say, a hospital system's computers are hit by hackers and ransomware is imposed, almost immediately class actions are filed. but no one in those classes can demonstrate that he or she has lost anything. That's the typical case. It's a concern that maybe it'll happen in the future, but not at the time the lawsuit is filed. The court has been asked on a number of occasions to hold that does not allow standing under the Act. And it's yet to happen, but again, there are cases in the hopper where the court might have a chance to answer about that. Another case typical is where the alleged fraud isn't really fraud at all. It's a question about billing or accounting that the government knows about, that bills continue to be paid, notwithstanding that knowledge. And again, does that make for a viable case? Some courts of appeals, particularly in the Fifth Circuit, have suggested that a case can't rise or fall on that. But the Supreme Court has allowed a substantial split in the circuits on all of those questions. There is a significant False Claims Act question that is coming up more and more, and as to which there is a split in the circuit. And that has to do in cases where the quality of care or the necessity of care is at issue. Is there an objective standard for such a matter where a plaintiff relator argues that a provider is providing and billing for care at a certain level, and that's unnecessary, and that provider is able to say, well, we have experts who can pass the test of Daubert, who are qualified experts, and they will say that under appropriate factual circumstances, which are not at issue, that the procedures at issue are reasonable to perform and exist within the range of actionable or permissible medical judgment. Does that end the case? Or where there is a war of experts, does the case continue, and is the trier of fact, judge or jury, entitled to decide whether there was medical necessity? Well, there's probably a range of cases where, in any event, that should be the case, where the expert being called upon is of such shady credentials that no one would believe him or her. But in the case where you have well-credentialed experts who do research, who've testified in the field, who are at the forefront of their practices, and they are conflicting with paid experts for plaintiffs who themselves could be well-credentialed, but that there's this battle of expert testimony. Can there be fraud under those circumstances where there is a legitimate issue in fact? Well, stay tuned. There's a big split in the circuits on this, and the Supreme Court is being asked in a number of petitions whether it ought to resolve the case. Not yet, but keep on the lookout.
Thank you so much for that. I would also just point out that should you and I be wrong about where the court is probably going in California versus Texas, that all of this could become immensely more complicated because we'll have an entire statutory scheme and regulatory scheme that a lot of these cases, the False Claims Act amendments from the ACA, open question of how far and how wide a ruling that the Affordable Care Act is unconstitutional and unseverable from that provision, what the impact would ultimately be there. So,
well, that's exactly right, Tim. And if guaranteed issue were to fall at the same time as 23 million people are divested of health insurance, at the same time when in the senior citizen category that I'm in have experienced the COVID crisis, and who, if exposed to COVID, at that point have demonstrable pre-existing conditions, how that's all going to play out, and whether a Congress can really get off of its chair and what sits on its chair to take emergency action. I think the court knows that. I think it's another reason why it's not going to categorically eliminate the Affordable Care Act. But if it does, you're dead right. We're going to be faced with a lot of maelstrom of activity.
Stuart, I wanted to thank you for joining us today. This has been an immensely informative conversation. I hope that our listeners were able to enjoy it. I always enjoy speaking to you about these matters and others. It's good to get insight from somebody with your wealth of experience. Was there anything else that you wanted to share with the listeners today before we close up to some?
Well, I will tell them this. I constantly get questions gratuitously on the internet or directly from clients, and I'm happy to answer them to the extent that I can with regard to the Supreme Court at sgerson@ebglaw.com.
Well, thank you. I also want to point out that you do have a blog series on LinkedIn, correct? SCOTUS Today?
That's correct.
SCOTUS Today on LinkedIn. You can find that on his profile on the Epstein, Becker, and Green website, and we'll put a link inside this episode. So thank you, Stuart. Thank you so much for taking the time to speak to us today about the 2020-2021 Supreme Court term and the related developments, as well as what we can expect to see coming towards the court in the future. I want to take a few moments to recap what we heard today. We heard that while the California versus Texas case could have immense consequences for the ACA and several other areas of law, we don't expect at this point, given the tenor of oral arguments and the issues before the court, for it to ultimately end up overturning the ACA. To that end, Justice Barrett will undoubtedly shape the law going forward. Her addition to the court is meaningful, though neither Stuart nor myself truly expect her to be the deciding vote in the ACA or the Rutledge case. But stay tuned for several other cases which cert is pending, where she could have a much larger impact. Finally, all of the consequences of these cases, how they come out, are going to be shaped by the response, both from Congress and state legislatives and the executive branch, and it will be forever changing landscape in the healthcare space and the healthcare law space. So hopefully you'll be able to stay tuned with us and reach out to us if we can be of assistance with understanding our developing world, both in a regulatory and legislative capacity. I'm Tim Murphy, and this has been Diagnosing Health Care. We look forward to having you join us again soon.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein, Becker & Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.